Petitioner. I can now 9 days second development. I am to withdraw the case with liberty file state. So only the okay. Right. Third, Mr. SRO. SRO, Learned Counsel for the petitioner who submits. Why this thing has been because the provisional it was cancelled. That was cancelled. Most probably it was cancelled. It was cancelled. I got an email. Okay. Mr. S.R. Gogoi, Learned Counsel for the petitioner submits that he would like to withdraw the writ petition with liberty to file a fresh, inasmuch as the provisional selection of the petitioner, provisional allotment of the retail outlet, the petitioner has been cancelled. Mr. Mr. M.K. Chaudhary appears for the IOC, IOCL, assisted by Mr. P. Bhadwaj. The writ petition accordingly dismissed as we thought, with liberty at stake. Okay. Like maybe I want to also finally we can bundle. Okay. You can do it on Tuesday. Item 18. Want to withdraw. Item 18 not refunded as declared defaulter. Okay. Item Mr. There are some developments. Okay, Mr. H.S. Bora. Then also for the petition. Submit that as there are some new developments. He would like to withdraw the writ petition with liberty to file a fresh. You are declared defaulter, no? That's why the security is not. Could not pay the kiss money. We couldn't pay the kiss money. Kiss money, yes, he could not pay. Anyway, right. Mr. R.R. Gogoi appeals for the Forest Department. The writ petition is dismissed with liberty. All right. Chip for the in the petition color. Give it. Much of. New case, old case. Give it. Old case, new case. Give it. I don't have 5 losses. Five losses. Yes. NK Muri out of Eastern losses. Huh? I am on behalf of NK Muri losses. Please out of Eastern, he telephone inform me then. AK Buyan? NK Muri losses. NK Muri. Mari. NK Mari. Give me that item file. Very thick. Lot of uses. I mean, environments here. So how does this cause any prejudice? I don't. Your problem. Huh? What? But what do you find? Yes, Mr. S. Roy. What is about this case? What is your? You're not read. You're not read. You don't even know the content. Next time you look at para 7. Okay, right. Adjournment prayer has been made on behalf of Mr. N.K. Murray. On the ground that he's out of state. On the ground that he's out of station. The matter pertains to a short e-tender notice dated 6/6/2024 and the corrigendum dated 29/6/2020. The respondent number 6 was selected. as prayer for adjournment has been made. This is the matter after review. Public.
Please a lot. People looking a fresh matter on Monday. The content.
Not much. Give it another thing. Not much.
Please, Lordship, I beg to let me allow to correct the item number 8. We have to submit it.
No, you cannot correct. Do it. Do it. Similar matters of 6 and 7. So we put Mr. Chamaria's name? Yes. Okay. Chamaria's name, 7.
Item number 1, 2, 3, 7, 10, 11. Similar method, similar only. 7 to
So we put Mr. Chamaria's name, huh? So, okay. Put it there. And then you say that registry to reflect the name of and SC, GAD and PNRD in the closet. Huh? Okay. That put it Kalpana, huh? So we fix your name or Mr. Chamaria's name?
I don't find my name may be repeated.
Just say, Mr. What is your name? K. Sharma appear for the petition. Huh?
A-N.
A. Sharma appear for the petition. That is it. And at the bottom you write that registry to reflect SC so is the positive. Like, right. Third, Mr. K.R. Patgiri, learned counsel for the petitioner, who submits that the contractual dues of the petitioner amounting to rupees
3,48,000.
Huh?
Page 22.
amounting to rupees 34 no 3 comma 48 comma 250 is not written. Issue notice returnable in 4 weeks. Ms. D. Jane accept notice on behalf of the respondent numbers. All the respondents. This is the matter of the police to enable the respondents to file their affidavit. License of creation system. His license has been cancelled, find out by the next year. So what is to be done? Appeal also is pending. So we direct that the appeal be disposed of. May be disposed of, that is page 36. Right. Third, Mr. and learned counsel for the petitioner who submits that the petitioner is having a fair price. I guess what you call Kalpana. Just call Kalpana. What was the and learned counsel for the petitioner who submits that the petitioner was given a fair price shop license for Kaya Kuchi Town and the MS Desh Bhakta DPSS Limited in the district of Barpeta. The petitioner's license was however suspended by order dated 24/9/2014 and the ration card holders of the petitioner's fair price shop were tagged with the nearest fair price shop of Saiz Uddin Ahmed of Kaya Kuchigaon. The petitioner's fair price shop license was subsequently cancelled on 14/8/2024. By the Deputy Director in charge, Food, Civil Supplies and Consumer Affairs, Corporate. And the respondent number 6 has been granted a license for running a fair price shop in place of the petitioner under the Assam Public Work.
Under the Assam Public Distribution of Practical Funds.
Assam Public Distribution of Articles Order Number 1980. Next paragraph. The petitioner sought to submit that the impugned order dated 14/8/2024, by which the petitioner's FPS license has been cancelled, has been put to challenge by way of by way of an appeal.
Page 33.
By way of an appeal dated 27/9/2024, which has been submitted to the District Commissioner Barfik. The petitioner sought to submit that the same has not been disposed of till date. He accordingly prays that a direction may be issued through the respondent number 2 to take a decision on the petitioner's appeal dated 27/9/2024, bracket NHS 7, and thereafter communicate the said decision to the petitioner. Ms. Yudas, Learned Counsel for the
1 to 4.
respondents number 1 to 4, submit that she has got no objection to the prayer made by the petitioner. In view of the consent of the party, the respondent number 2 is directed to take a decision on the petitioner's representation dated 27/9/2024. Representation / appeal dated 27/9/2024. Wherever it says appeal, you make it representation / appeal. Within a period of, because notice will have to be given to the others also.
Fine.
A period of 2 months from the date of receipt of a certified copy of the law. The respondent number 2 is also directed to give a decision on the representation / appeal dated 27/9/2024 after giving an opportunity of hearing to the response number 5 and 6.
5. Okay.
The writ petitions accordingly disposed. Okay.
May please. Notif. Petitioner is entitled for declaration.
No, I don't think so.
As per MS.
Did you ask for interest in your other case in WPC 761 of 2019?
Yes, I have of course asked.
And did the court give you? Did the court grant you interest in your earlier writ petition?
In other petition,
That has attained finality. You go file a review there, or you file an appeal against their order. Dismiss.
Notif,
No case.
my representation on.
No case, no case. You see, representation, there's no question of representation being considered for the simple reason that you had asked for, in your earlier writ petition, you had asked for payment for supply bill for April, May, June 2018, correct?
Correct.
Now, all of them have been paid. You have also asked for interest as per the act. That has been nothing has been stated by the court. Basically, it implies that it was denied. So, you cannot come now in a separate writ petition asking for interest, because out here you have asked for, because the court had said you should pay within 3 months. So you are saying that the due date will be 3 months in terms of the act, because the money was not given to you within 3 months. But as per the act, section 50, 60, 17, the due date is not the order of the court. It is as per the act. You cannot play around, Mr. Kaur. Why should I not impose cost upon you? for trying to mislead the court.
Okay.
Huh?
Let me allow to type it.
I'm not anyone to allow you to file a review.
Got it.
Huh?
Got it.
No liberty. You want to withdraw, I'll allow you to withdraw, otherwise I'm dismissing the case. With court. You cannot try to mislead the case for court like.
I should,
I have got that earlier writ petition of yours. In para 10. Where is that? In para 10, you have made that you have made very categorical submissions with regard to the act. And you have also in your writ petition quoted section 15, 16, 17 of the act for payment of interest. You have also made a prayer in the writ petition. Not granted. Now you are coming by way of this writ petition. Trying to make a mockery of the entire process.
In fact, it petition is annexed.
Huh?
It petition is annexed.
No, he doesn't want to show.
Yes. Page number 23, para 10. Yes, next the it petition. It amounts to a second it petition.
Correct.
Page 23. Yes, next the it petition.
Oh, that means he has not intentionally hit. Anyway. Okay, dismiss.
I have to withdraw.
Huh?
I have to withdraw it.
You want to withdraw? Okay, heard Mr. P. Fukan for the petitioner and Mr. S. Bora for
All the response.
all the respondents. Huh? Then you write everything. So whatever it is, I'll at the end. Just write. Mr. P. Fukan says that he may be allowed to withdraw the writ petition. The prayer is allowed, writ petition dismissal because. No, he just replied. Put everything down. Okay.
But the voter matter.
The voter matter. So we'll send it. Let the SP do the. You're Mr. M. Ali. And you're Mr.
G Sharma.
D. Sharma. Huh?
For respondent number TN6.
D. Sharma.
G.
G. Sharma for respondent
TN6.
3 and 6. Miss U dash for respondent number 5. Anybody else?
Therefore, H to D.
H KULI.
On behalf of AIN.
Huh?
On behalf of AIN.
Yeah, faithfully on behalf of AI Ali for respondent number 2. Who is for 6?
6 I'm ready.
3 and 6 here. You are the main person. You are the SP.
Yes.
Okay. We are disposing it out. So he has to do all the job. All right. Supply bill.
Okay, so protected fee.
When was the supply done?
The supply started from sometime in 2019 and the last supply was given in March.
Have we done this? No. Heard Mr. P. Bhardwaj, Learned Counsel for the petitioner who submitted. Says the petitioner supply bill amounting to rupees 3,37,21,536 for the supplies made during the period 2019 to 2022 has not been given to the petitioner till date. Issue notice returnable in 4 weeks, Mr.
I'm for responsibility of
Name
it for
SMGTC appears for respondent number 3. Respondent number 3. Who else?
Apron is the respondent. They don't
Huh?
have that. Apron is the respondent. They are the main party.
Okay.
They are
Okay. Petitioner takes steps for service of notice upon the respondents number 1 and 2 by registered post within 5 days. List the matter after. Why you make it returnable in 5 weeks? Huh? List the matter after 5 weeks. to enable the respondents to file their affidavit.
Lordship, here the main grievance against the department is the agricultural marketing board. Lordship, they have a separate standing council. Their name is not only the corporate. Lordship, their grievance is against the marketing board, only, not against the department.
Have you given them, Agriculture Marketing Board, have you given them a copy?
Not given to them, but
Yeah,
that party, we have could not find.
You cannot find them. Who is the,
Gogoi.
who is the Agriculture
NJ
Marketing?
Gogoi.
Huh?
NJ Gogoi. He is
NJ Gogoi. You call him, we'll wait for you. Call him,
Yes,
please, call him, then we'll take it up. Wait, please, your lordship, my lord.
Petitioner, my lord, who is the sole proprietor of the petitioner one farm, my lord. Running a small grocery shop. Now the ESI authorities have held that the act is applicable, no difficulty. Now, by a prohibitory order, an amount of around 12,80,000, my lord, that is the including interest. And because of the prohibitory order, my lord, I am not being able to operate my
You
bank.
pay the amount, simple, then
No, my lord, lordship will kindly appreciate the provisions of section 75 of the act. Because against that order under 45, my lord, I have a remedy to go before the EI court, employees insurance.
then have you gone?
But that court is not sitting on it. That is my specific case. There is no incumbent.
speaking circular in charge. And Malay is similar order. There is also another authority providing under section 45 double. Your lordship or not? Similar. 45 double. There are
Sarah, see,
there are
45A.
45 double.
My lord, that period is over, man.
Even in the same case, the limitation was for the property portion.
My lord, I am in trouble, my lord, both ways, my lord. The bank loan, I am not being able to liquidate. I am ready and willing to pay that.
We'll ask the appellate authority to take a lenient.
They have 45 double or the as possible.
You apply either for 45AA or section 75. That's all. 75, you said that there's no.
There is no incumbent. my lord.
Speaker session judge is in charge. They may move the case.
There
This
has
is
to be- there has to- under 74, my lord, there has to be a specific appointment of the EI court, man.
Or that 45
There has to
double.
be a gazette
45AA is there.
Similar order.
Correct.
Lordship is directing the appellate authority to decide.
That's it. If
Within a time frame,
where there's an alternative remedy, statutory alternative remedy, yes. There are enough judgments of the Supreme Court which say that when there's statutory remedy, then they have to go there.
Something about the time frame may kindly be fixed, my lord.
Time frame to let them decide.
Because
We cannot,
no, my lord, lordship will kindly appreciate, my lord. Otherwise, I would not have. Interest on the bank loan is mounting. 48 lakhs is the demand, my lord. And here also per day interest
Look,
they are claiming
you
to 61.
you have got liability of around 48 lakhs with the bank, according to you.
Right.
And you have got liability with them of 12 lakhs,
13 lakhs.
13 lakhs with the interest. You pay the 13 lakhs, then when we
No, my lord, even under 75, I'm required to deposit only 50% before the EI court.
then you go,
There
you
is
go.
no EI court, and I would have gone, my lord. That is
Oh
the-
no, now you go you go to the authority under 45A.
Lordship will kindly fix a time frame, my lord. But let them decide within.
Let's paraphrase with this. Mr.
And my lord.
M. Smith,
For 2 to
M. Smith, the learned counsel for the respondent numbers
2 to 5.
2 to 5. Submit that an alternative remedy is available to the petitioner by exercising the options under section 45A or section 75 of the ECI Act, 1940.
45 double A.
Huh?
45 capital double A.
45 double A.
45 double A.
Correct. A, that's what it is. A.
Sorry.
He submits that even though the petitioner's counsel has taken a stand that there is no incumbent who to whom an appeal can be filed under section 75 of the ECI Act 1948, an order under section 45A can be put to challenge by way of appeal before the appellate authority under section 45A. So accordingly, the petitioner should be directed to approach the appellate authority. Then you take this, para 4, para 5, para 6, para 7, then in this para 7, let us put A, that's it. In the event that the petitioner files an application under section 45A against the order made under section 45A, the appellate authority should consider disposing of the matter at the earliest and preferably within a period of months. No, it cannot be.
Expeditiously as possible.
And expeditiously as possible.
With the bank, my lord.
No, I cannot order other authority.
No, my lord, I'm not
Right.
asking for an order against the bank, my lord. Only expeditious disposal of
Because
the
enough.
matter, my lord.
Accordingly, then we make this para 8. It means with liberty being given to the petitioner to approach the appellate authority.
Of course, you cannot use the word dismiss, my lord.
Huh?
That may cross the
But
petition. Disposed of.
okay, according to the writ petition disposed of.
So that may again cause problem.
Disposed of, with liberty to. Then instead of in para 8, instead of saying dismissed, you make it disposed of. Okay. Mr. S. S.R. Baru appears for number. Then you put their names in the beginning, all this. Mr. So forth, so M,
And
M
data for
data. N data.
Alright.
Here's the part is here. Right. What is this?
Your Lordship, a holiday has been imposed upon me. Against that, I have preferred an appeal. As per their banning policy,
So that appeal has not been disposed of.
yes, because as per the banning policy,
I am not
45
able to
days.
get my instructions as of date as to regarding the state of the appeal. But if it is not been disposed of, then it will be disposed of.
Only at that time, because
Yes, within how much time?
I would prefer 7 days because now, as per the
Only Diwali, let him enjoy Diwali.
Okay,
Where you
15
think?
days. Because already 88 days
Huh?
have
3 weeks time, Lord.
Appeal is of June,
Yes, but
July, August, September, October. It's a
I
civil
don't have-
debt.
I don't have
Blacklisting
instructions
is a
whether it
civil
was
debt.
received in June or not.
it
by
has
the-
been, it has
by
been.
No,
Yeah.
blacklisting is a civil debt.
Yes.
Then,
15 days, Your Lordship will be.
though it appears that he's not been very diligently working.
I will satisfy that. That's the matter for arbitration. I will not open up here.
No. Prima facie, from the facts of the case.
My predicament is I do not have the instructions as of date,
No, it's okay.
whether the appeal has
No,
been
no, you
actually
see,
received by them or not.
it is
Because it was reflected.
Blacklisting for 1 year also is put to challenge. They need to ask for a month. Despite his
21 days I
appeal,
am asking.
despite his appeal being there for the last 3 months,
Whether
Policy
it-
four
says
months.
45 days.
4 months, July, August, September, October.
Yes.
4 months gone, more than 4 months gone.
whether the appeal has been received by the authorities or not, that instruction I do not have. That is what I'm trying to. Because it doesn't reflect in this appeal whether it has been received or not. So this is not been annexed here in this petition. So I do not know. That is the only thing. If it is there, it will be disposed of, or it will give us 3 weeks time. to get it. That is my.
Because all,
Okay, within 3 weeks from today. But no, but then once we have got to give them the order also. You've got to give them the order.
Yes, yes.
But my friend is there.
Unless you give them the order, then it's a problem. Okay, right. Right, Mr. D. Senapati, learned counsel for the petitioner, and Mr.
A. Sharma.
A. Sharma for the A. Sharma standing counsel for the
All India Limited.
All India Limit. Huh? Then you just say, just say in the at the cooperative portion, you just say, as the petitioner has submitted his appeal against the speaking order on 18/6/2024, the appellate authority is directed to take a decision on the petitioner's appeal within a period of 3 weeks, within a period of 15 days. 15 days from the date of receipt of a copy of this order. The writ petition is accordingly disposed.
Obliged.
You see that process, then you can, then
May I please? Here, my lord. Person to NIT issued by the unclick concept, my lord. Teacher of public is tender. But
item
20.
24.
29/6/24 notification they are filling. This matter is having fixed on 12/11.
12/11.
Similar order I have about 10 actually. Please, my lord.
So the respondent number 6 is now being given the thing. No.
My lord. Actually, they have been given the extension to random market. So,
Who has been given the extension?
my lord, by this, my lord, government notification 29/6/2024.
But then
The your lordship has already, in similar cases, your lordship has only stated
Problem.
extension part.
Problem I've just found. The ex-lessee is not a party.
that is what I found also. That person is not a party here.
Well, here I have an improved order, my lord, where the
Mr. Counsel,
common order, my lord.
Mr. Counsel, please understand. When you want an order passed against somebody, isn't that person supposed to be made a party?
My lord, in fact, here is also, my lord, serious omission was passed this common order as a district, my lord. So that part is already.
All the private parties were there.
My lord, page, my lord.
Page 30.
Page 33, my lord, paragraph 7. My lord.
33. Yes.
Yes. In this case also, my lord, private party was.
But out here, Mr. Counsel, in this case, they have asked the erstwhile settlement holder to, not erstwhile, the earlier settlement holder to continue. You have to make him a party.
Your lord, kindly please 30, my lord.
You please make him a party. If you make him a party, then to make him a party. Otherwise, I'll list this matter on 12/11. That's it. No stay order. Huh? Okay, Mr.
You know.
B. Raman, learned counsel for the petitioner, please that he may be allowed to withdraw the writ petition with liberty to file a claim. Mr. S. Datta appears for the PNRD department, while Ms. U. Das appears for 2. This is point number 2. The writ petition is accordingly dismissed as withdrawn, with liberty of speech.
I'm being under 50.
Obliged.
15. 15 is with regard to dues.
Yeah.
Yes, please for the Agriculture Marketing Board. Okay, very good. Mr. What is your name?
Yeah.
Mr. J. Abbas, learned counsel for the petitioner, submit that the petitioner's contractual dues amounting to rupees 65,44,788 has not been paid. Issue notice returnable in 5 weeks. Miss S. Dev, DB, appears on behalf of N.J. Gogoi and accepts notice on behalf of response number
3, 4, and 5.
3, 4, and 5.
And I for warrant.
Mr. SMT Chistry, SMT Chistry appears for respondents number 1 and 2. Extra copies of the writ petition be furnished to Ms. S. Dev during the course of the day. List the matter after 4 weeks to enable the respondents to file their affidavit. Blasted by
Just to non-payment of contractual.
Okay, right. Third, Mr.
RS Mishra.
R.S. Mishra, learned counsel for the petitioner who submits that the petitioner's contractual dues amounting to rupees 34,42,962 and security deposit of rupees 15,41,250 has not been paid despite completion of the contract by the petitioner. Except a issue notice returnable in 5 weeks, Miss
Iwapangla.
T.
Iwapangla.
Wapangla,
On behalf of
appearing on behalf of Mr.
Armasindar.
R. Mazumdar, accept notice on behalf of
All the
all the respondents. This is the matter of the 5 weeks to enable the respondents to file their affidavit.
Made this, your lord. My lord.
Yes.
Yes, my lord, this petitioner association is a vending and catering association, my lord. Having shops and stalls, etc. in a particular railway station, Tinsukia railway station, my lord. And they have been carrying on for long. And they have vending licenses at point of time. Now they have been impliedly they are giving the licenses and they are carrying on the business. Now impugned notices are paid 106 and 108, my lord, by which they are asked to vacate the premise by tomorrow.
When is the what is the validity of your license?
Validity of the license expired, my lord, at 2015 and 2008, respectively. My lord,
2015 and 2010 and 2015 expired.
yes, my lord, may I just point out one thing?
100 and page 100 and
Now, my lord, I just point out page number 193, an interim order of the Honorable Apex Court in a similar matter from the Guwahati High Court, my lord. Here also, once that a Lambing Association, another association, my lord, similar association, went to the Apex Court, my lord. Here this order was passed. And that was also a challenge on the ground of livelihood. Here also question of livelihood, we have, my lord, we have taken up that particular. Here, my lord, in the interim, my lord, that at page 195 is the order, my lord. And 197 is the particular.
Huh?
197, my lord. So here, similar association, that is Lambing Association, my lord, they have also challenged the policy, and that was dismissed by this honorable court, and thereafter by the division bench, and thereafter, my lord, the association approached the honorable appellate court. Here, my lord, the matter is at present subsidized, my lord, and my lord, there is an interim order till the next date of hearing. The members of the petitioners association shall not be dislodged from the space under their occupation, and they shall be allowed to carry on business without prejudice to the rights and contention of the respondent. My lord, our association is also similar association. I only pray, my lord, since this.
what is this order dated 13/8/24? Okay. Yes.
My lord, these issues are covered by lordship judgment. My lord, I have earlier similar issue, my lord, that the rights of renewal under the 2017 policy, lordship has already held that there is no right of renewal. That was affirmed by the Honorable Division Bench, our bench. And the judgment which my learned friend is relying on the Supreme Court judgment, my lord, the August 2024 judgment, that is in a different context. That is not, my lord, related to that, my lord, because that is entirely in a different context. But the division bench judgment of our Honorable High Court, which has affirmed lordship judgment, that there is no right of renewal under the 2017 policy. And once the agreement, my lord, at page 33, the agreements have expired long back.
2010 and 15.
15, my lord. And by the order of impugn order, my lord, we have stated that we participate in the new tender. But that right of continuing cannot be for
Continuity does not exist anymore.
Yes. Cannot be continued for lifelong.
My lord, here, the Lambing Association case, my lord, I personally represented in the honorable court. That was also similar to this. We have challenged that livelihood, my lord. So, in any aspect of the matter, my lord, since the other association is that they were allowed to carry on their business by means of this order. My lord, I only pray that till that The next step, my lord, we may be allowed to carry out. At 197, my lord. Whatever the outcome will be bound.
No, this is different.
My lord, this.
That was withdrawn. The earlier SLP was withdrawn.
Thereafter, we filed it, review was filed before the honorable court. And thereafter, after the review, SLP was prepared. In the SLP, this order is filed. This order is filed.
Those orders also have been annexed.
I have ordered, I have an one
So in the review order, that was in a completely different context.
Yes.
But my lordship ordered of non-renewal, that my lord, WPC, Deepak and Company order, my lord.
Yes.
Writ appeal one, my lord's order is, my lord,
WPC 1828.
yes, 1828 of 23. Lord, paragraph 17. And my lord has taken note of the judgment which is now impugned before the apex court, my lord, this W8 47. Paragraph 16, my lord.
You have not paid your dues also.
we have been paying till date, my lord. We have been paying.
There is no right of renewal. My
No
lord,
right,
see
no right of
paragraph-
renewal.
Paragraph 16, my lord, will see the judgment and orders passed in W55-313 of 17 and 5143 of 14 were put to challenge in WA 47 and WA 54 respectively. The division bench of this court disposed of 47 of the 23 and 54 white common order dated 13/3/23, wherein it did not interfere with the decision of the learned single judge, which had held that the catering policy 17 did not provide for renewal of license of catering when public stalls. It also did not interfere with the direction passed by the learned single judge, wherein liberty has been granted given to the railway authorities to resort to such action as they deem fit in terms of catering policy 2017. It also did not interfere with the finding of the learned single judge that the catering policy 2017 did not provide for the renewal of license. Now, against followed the judgment in WA 47 of the 23, they have preferred review 117 of the 23, my lord, at page 96, which my learned friend is relying on the judgment. That review was also dismissed. Against that, an SLP is filed. Therein, my lord, some interim protection is there till the next returnable date only. But that does not, my lord, but the very order of our
Still, it's not been
still
stayed.
not been, that is
Not stayed.
My lord,
and this order has
Here,
been
in
passed,
connection with.
Just a minute.
and this, the direction, the impugned order which is under challenge, my lord, has been passed pursuant to directions by your, my lord's order, my lord, page 60, page 89. Page 89 starts from, the relevant portion starts from page 94 and the direction, my lord, page 96, paragraph 8. On considering the submissions made by the council for the parties and keeping in view the fact that the new catering policy of 17 has replaced the earlier catering policy of 2010, besides the fact that the contract agreement between the parties has expired way back, the present restrictions are being disposed of in terms of paragraph number 22 of the judgment and order dated 29/4/22 in WPC number 6470 is as follows. Taking into consideration that by dint of the interim order, which are still paying title fee as the existing rate within the year 2000, delivered for at liberty
to enhance ESSP liability of the petitioner originally every 3 years on the basis of actual turnovers of the unit in the manner to be done in terms with clause 6.3 and 6.3.3 for the period with effect from 1/11/2010 till the date of the instant judgment and to claim such instant amount and areas there in terms of such statement. It is clarified if materials data are not available, then the rate authority will be entitled to minimum enhancement of 10% every 3 years till 1/11/2020. Further, to that, the respondent authority shall also be at liberty to take such steps as envisaged under the law as per the present existing policy in respect of the litigation. So in terms of that, my lord, these impugn orders are the orders were passed, my lord, at page
106.
106. Now, the reference has been made of the judgment of the Honorable High Court Order, my lord, in the legal opinion by the General Manager Law. And my lord, in the last paragraph, it stated that you are therefore instructed to clear all the area and enhance license fee. And then say closure of the above mentioned unit and removal of the temporary structures by 31/10/2024. Further, it is advised to clear all enhanced license fees due before 31/10/24. However, it is clarified that upon payment of the license fee of the above mentioned license fee, they will be eligible to participate in fresh tenders, the option floated by. Because if we open a floodgate, because
Correct.
otherwise this 2010-17 policy, if we
And there earlier agreements were made in terms of the 2010 policy.
10 policy, it is 33, my lord. That period is already expired, about 1/11. And the order, my lord, the order already passed by the court.
Yes, but
My lord, here, that what transpires from my lord's order, that so then enhance this can be, that they will give us the reason, my lord. Here, this particular two notices does not give any reason. Simply, my lord, this,
okay, that you
Yeah.
challenge,
my
that
lord,
you challenge.
I just say, my lord, since
You
Tata
cannot have your
Plumbing
case.
Association is a, my lord, that's a junction, my lord. Since they have been protected, my lord, till 13 November, whatever outcome, my lord, that will be final, my lord. Because by then, my lord, here, we have challenged it and also in the ground of livelihood. Because, my lord, we have been carrying it. So, my lord, up to 13th November, my lord, since same protection has been given by the Honorable Apex Court, my lord, I say that similar priority may, my lord, of the judgment. Whatever decision there would be, my lord, will be extremely bound by that. We have no other.
Heard, Mr.
Yes.
P. Hazari Patel, counsel for the petition. To submit that the members of the petitioner association at Mariani and Parkati railway station were served with two notices dated 23/10/2024 and 20/10/2024. Separate, mentioning the names of each vendor of the railway station, instructing them to clear their individual areas against their respective stalls / vending units before 31/10/2024. They were also instructed to close the respective units and remove the temporary structures by 31/10/2024. The said notices were issued in reference to the common order dated 24/2024 passed by the in WPC. WPC number, where is this 1131?
Page 89.
Huh?
Page 89.
One. But that is 2693. It's different.
1131 was included in that law.
In,
Page
yeah,
92.
it was there. Okay.
Page
In 1131 slash 2012, which was tagged along with the leading case, that is WPC number 2693 of 2000. The petitioner's counsel submits that despite the submits that in terms of the said common order dated 23/4/2022 passed in the above cases, comma, the basis for the actual turnover of the unit to be done in terms of clause 18.3 and 16.2.3 with effect from 1/11/2010 is not discernible. It submits that besides the above, comma, the issue relating to eviction of similarly situated persons pending before the Supreme. Is it?
And they have been protected.
And as they have been protected by the Supreme Court, comma,
Yes.
in WPC number, in SLP,
SLP.
C number 17501 1 17502 2020. By order dated 30/8/2024. The eviction of the petitioner in the present case. So the proposal to evict the petitioner in the present case, it states,
My lord, here I am also.
till a decision is taken by the,
like you.
till a decision is taken by the Supreme. We also submit that the livelihood of the petitioner being at stake, this court should consider the case of the petitioner. Lenient. Mr. H. Gupta, the learned counsel for the railways. On the other hand, submit that the issue before the learned before the Honorable Supreme Court in SLPC number 17501 17502 2020 is different from the present case. He submits that this court in similar matter has already held that as the catering policy of 2017 did not provide for renewal of license for catering venues that all, comma, the person whose agreement made in terms of the catering policy of 2010 cannot have any legitimate right to have their catering vent stall extended beyond 5 years in terms of the catering policy of 2007. We submit that the above decision of this court in WPC 1828/2020 has been upheld by the division bench of this court in WA number 54 or 23. Wait, they lost that. How can it be lost? In WA number 124 of 2020, by judgment and order dated 11/3/2020. As such, there is no case of as such they did petition to this. That's all.
Yes, and furthermore, the agreement has already expired, so that
Put up you further submit that the agreement executed between the uh, petitioners and the railways for running the stalls and railway stalls and vents has expired in the year 2010 and 2015.
2015 was.
2015 is the year 2000. As such, as as the catering policy of 2017 does not provide for extension that renewal of the license for catering when that stall come up. No right of the petitioner has been violated on account of the railways seeking to issue fresh license on the basis of fresh tenders, is it? Fresh allotments, fresh allotments to be made in terms of the catering policy of 2000. Next part. Okay, what about this SLP he's talking about again? That is with regard to which case that SLP is the stay order.
My lord,
No, that is
Just a minute, I've talked to him.
no, that is a different, no, that's not related to these facts. 20%. So this order is passed pursuant to order by Lordship in WPC 1131 of 2012. This referred.
Next, on constitution. Right, did you notice this returnable in? There is nothing here.
where is coming from?
Already they have, but 2015 itself will access,
That is expired.
but still they got the bonus till before they were now allowed. For it. Now, my lord, so the authorities are deciding to go ahead for a bed tender. They have indicated in the order, my lord, liberty is given to participate in the bed tender process. Like,
That's right. The fact of it is the case, the admitted case is that the the petitioners were granted license for running catering when that stop till the year 2015.
My one point remains.
When the
I could not address.
Huh?
One point I could not address, but I was trying to address.
What?
One point.
what?
That, my lord, in 2017, this particular landing with this interim order was passed. We have challenged the very policy 2017.
You may challenge unless
Yes,
the
and here it said, my lord,
When the-
the existing policy in respect. So when, my lord, the policy was challenged by one association, and there is an interim order. That is why for the ends of justice I prayed, my lord, nothing else. Because that I have been, my lord, conducting that particular.
right. I will issue notice if you want. That's all, nothing. Otherwise, I'm going to dismiss it. Huh?
against the order of the division bench. He was also dismissed by.
Against this,
Yes, that review order, no, my lord, the order which my learned friend is
97.
197 order. That
Hmm.
is challenging the order passed in the review petition. That order has not.
this is 197, page 197.
Yes, 196.
This is against the review order.
Yes.
This is against the review order.
Yes. So this, there is no stay, my lord.
No, but you see that what is that review order? What is that review order?
Review order, my lord, has not been made. Not been announced.
What is the review petition case number?
117 of the 23.
117 of
23.
23.
23.
This is against which case? WA number
WA number 47.
47 of
20.
20. And WA 47 of 23 is against.
Okay.
Where is it in page?
I 5313, my lord.
Which page?
Page I have. It's not enough.
The problem was this was a supplementary. I didn't really have time to go.
5313 was there.
And I was not the one who gave permission for this. It was by page 5. And it came to this. That's why I didn't have time to get it.
My lord, may I have it be order?
No. This
Here, my lord, that policy was
Actually, my lord, there is no right of renewal. That has been affirmed. That is nowhere stated.
oh, right, okay.
So there is no stay of the
Right.
of the budget.
What have I said? When is that judgment of mine that is here in the writ petition? Which page? Page 94.
89.
59. 92 is the relevant. It is connected with petition. 1131 at page 92 it is reflected. Or link page.
1131
1131 of 2012.
11. Which page?
92, my lord. Start from 59.
Okay, 5313 of 17 and 5416 of 17 was challenged in. Right. So catering policy was challenged. Right. What have I said? I have. Get to case that. Yeah, good stuff. It is also it is also a fact that the catering policy of 2017, which does not provide for renewal of license for catering well slash stall has not, is still, has been considered to be valid by this court and the division by this court. And the challenge put to the state by WPC 5313 of 2017 has been dismissed. By order dated, by judgment and order dated 24/1/2020. The appeal against the judgment and order passed in WPC 5313 of 2017 in WA number 47 of 2023 was also dismissed. The SLP number, what was the SLP number that was filed earlier?
Number 17501 17502 of 2022.
Where is that?
That's page number 190.
190?
Five.
No, the earlier. Sorry, the SLP was filed out against that judgment of the division bench. Where is that SLP?
That's fine.
Don't try to mislead. This is a separate SLP.
This is after review.
I want the one prior to review. The SLP
Prior to the review.
files against the judgment passed by the division bench of this court in WA 47 of 2023 was withdrawn by the petitioner, by the appellant in WA 47/2026, and a review was filed against the that order passed in WA 47 of 2020. By review petition number. Yes, what was the review petition number? 117 of 2023. Correct. The review petition was dismissed by the division bench of this. Next part. The dismissal of review petition number 117 of 2023 by the division bench of this court was then again put to challenge in SLP P 17501-17502 2020. However, the Honorable Supreme Court in SLP 17501-17502 2024 was of the view that when the earlier SLP had been withdrawn without liberty being taken to file the same effect, a fresh SLP could not have been filed. However, as the issue, no, however, as there was a contrary order passed by a bench of equal strength of the Supreme Court in another case, the said issue was referred to a larger bench, Supreme Court, for its decision. It was in that context that this court, that the then Supreme Court had directed that the members of those associations should not be dislodged from their places under their occupation. So won't it be slightly similar, Mr. Gupta?
Well, in fact, the fact that the order by this decision bench has affirmed the catering policy. Those were not before the, well, in the SLP. And this stay is still the returnable date, my lord, only. Maybe only on the humanitarian grounds, but the aspect of the matter that this bench has already affirmed the catering
Next
policy,
para, you're right.
that has not been brought before
The above being said, comma, the judgment of the division bench of the High Court affirming the decisions of the single bench shows that the catering policy of 2017, which is being applied in the whole of India as on date, has been upheld. There is no stay granted by the Honorable Supreme Court against the review petition, against the against any order of the division bench of this court or single bench of this court with regard to the catering policy of 2007, especially when the person running the catering events at all agreement have expired. In the present case, the
one more thing that I want to point out, my lord, the order passed by, Lord, my lord,
you go,
WA one,
you go, I'll put it, you go.
the order passed by WA, my lord, 124 oblique 23, my lord, that has also been challenged, my lord, and the SLP has been dismissed. That was put to challenge, that is, take the order, it has been affirmed.
In WA 124, full stop.
WA 124.
It should also, this court is also, has also been made aware of the fact that the judgment and order dated 11/3/2024 passed by the division bench of this court in WA number 124 of 2020 was put to challenge in the Supreme Court by SLP
Number, my
D
lord,
number
17338
1738
2024.
2024. The same was dismissed on
My lord, 25/10 2024.
25/10/2020. Correct.
Yes.
In that way, the matter, this court does not find any ground to allow the writ petition. The writ petition is accordingly dismissed. The proposal was brought in place for the matter. Okay, Mr. B. Gogoi, land counsel for the PWD. Submits the proposal for payment of the contractual dues of the petitioner amounting to rupees 6.10986 has been placed before the finance department for approval on 12/9/24. 12/9/24. He submits that he will obtain the up-to-date status report with regard to the that proposal. That is before the finance department. So this is the matter on after 4 weeks. Miss. Yeah, then you write her name also, Miss S. Dev appears for the petitioner, huh? You put all their names.
And people notice we have taken the fresh steps in all the cases.
No steps taken till date, that is what is written here. Please give me. Right, Mr.
KJ,
AJ,
KJ.
KJ appears on behalf of the review petitioner. Review petitioner, huh? Review petitioner. He has submitted an acknowledgement receipt issued by the registry of this court showing that steps have been taken by the petitioner for service of notice upon the respondent on 30/10/2020. Oh, 30. Today he is taking step. You have got a case, no doubt about it. Uh, uh, this is the matter on give a date. 4 weeks, 4 weeks. This is the matter on 3rd December. You're right. It is also this is the second time that notice has been issued to the respondent. This is that before that, then we release the matter. Will be otherwise your case is clear. Actually, that order has, I think, needs to be reviewed. So we're on third.
Judgment of the FH for
You give me that.
will place it on the next day.
You give me, I'll write it
I
here.
have that.
Then you just write. Don't give it on third. Give it slightly earlier. Fourth. Oh, 1 month. 1 month should go. Today's 30th. Oh, third. Okay, third. Which para? No, one is that Ashish.
Ashish is the, I have to make two leaves.
Okay. Which, so the, 26. Which paragraph?
Here I will,
Okay, just write it on the top, the front page. I want to be incorporated in your system. A prima facie perusal of the order. No, a perusal of the issued order. Prima facie shows that the petitioner, the review petitioners may have a case. The review petitioner may have a case in terms of the judgment of the Supreme Court in Union of India and others versus Ashish Agarwal. Reported in 2023, 186.7, then dash and those two things. Because this Ashish Agarwal is because the notice was prior to 1/4. Anyway, on the next date we'll dispose it. I just put that case number.